Bill's asleep, guys. So we have to be quiet. Bill's not going to join us today, but he is in spirit. I mean, he might stop in. Who knows? Who knows? Into chat to say hi much, much later in the morning. Hi, guys. It's Kathy. I hope you're doing well. I miss Bill. So we're going to fake it today. But 2 housekeeping items first. Later today at 1 o'clock, we're going to be continuing. We're going to do another live stream, and we're going to continue with that dementia guy who has been on death row for 39 years, and now they say they can't execute him because he has dementia and other reasons. So we're still trying to find out if he's scheduled in 19 days, I think, or 20 days, right? To be shot by a firing squad in Utah. So Josh is keeping an eye on it. And the next hearing was 2 days ago, I think. So I got it. Josh sent me a text and I got it real quick. We're going to show that later today. There's no decision yet. It's coming. I'm hoping the decision does not come until after Tuesday. And you'll find out why I hope it does not come until after Tuesday when you see the live stream. Second thing, I won't be streaming tomorrow. I'm taking a day off tomorrow. Ooh, there goes my voice. It's my dad's birthday, so I'm taking the day off. All right. We are going. I miss Bill. So we are going to watch Bill, but not really Bill, just his work. That would be great. Hold on one second. That would be great if we could just have a whole 2-hour video of Bill. And you know what? I could do that. I could do that some days. Go in and just record Bill on each of his clips. Play a 2-hour video of Bill. He would not love that at all. I might do it anyway. At least 30-minute clip of Bill, right? Sorry, I was screaming a lot today. There was a lot of screaming involved. I guess yesterday, I mean, a lot. So my voice is really struggling. Oh. Good. It works out. Wait. Sorry, I'm deep in thought right now. I might take 2 days off, guys. No. I have a job interview on Monday, a pretty big one. And that's what I'm taking off anyway because it's my dad's birthday. So, nope, that's just one stream. We're just going to miss one stream. All right, here we go, guys. Here we go. This is American courts. This is from a bit ago. This is the link. Okay? All right? Go like it at least. I mean, it'd be better if you could just watch this stream over there too again so he gets the views. But at least go like it. At least go click the like button if you haven't. I did. See, look, see, I can see that I liked it. But a lot more people can like it. It's CJ, I don't need luck. This is perfect for me. This job has me written all over it. But let's go.
On the prosecutor's side, who is going to, or is Ms. Landy going to do it remotely?
I'm happy to do it remotely, Your Honor. Good morning.
How are you so special?
I am within an ice rink, so I appreciate the accommodation for me. I really do. Thank you.
No, and we had no problem doing that. Although the rest of your office is here. But go ahead,
They
please, Ms.
are
Levy.
an intrepid bunch, are they not?
Yes, they are. Court calls case People versus Teresa Johnson. 3 cases.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson, who appears via Your Honor.
Ms. Johnson, can you state your name, please?
Yes, sir. Teresa Johnson.
All right. I have before me 3 plea forms. Is that what we're doing today?
That is correct, Your Honor. I previously sent.
Shut up, Judge Simpson. Look, there's Bill. Hi, Bill. How are you today, Bill? Guys, do you have any questions for Bill while he's here? If you have any questions, let me know. I'll ask him. All right, back to work.
The police reports for purposes of a no contest plea.
Yes. And they're all, I understand they're all no contest pleas. correct?
Yes, Your Honor.
All right. And the plea form starting in case ending in 5152 indicates that she would be pleading no contest to the charge of the stated count of assault and battery and an added count of attempted resisting and obstructing, the assault and battery being a 93-day offense and the attempted resisting and obstructing a 1-year offense. Also on case ending in 5189, she will.
There's Maria. There's Fozzie's pants. Hi, Fozzie's pants. We get to see everybody's comments, and that'll be fun.
Be pleading no contest to the same charges of assault and battery, a 93-day offense, and attempted resisting and obstructing a 1-year offense with dismissal of count 1. There was also a global agreement to 2 years probation with assessments, treatment, full restitution on all counts. To the extent that's a sentencing issue, I cannot find the sentencing judges in this case.
Understood, Your Honor.
So, and on the case ending in 70779, she is going to be pleading no contest to counts 3 and 4. Also, the charges of attempted resisting and obstructing the 1-year offense and assault and battery, the 93 offense, with dismissal of the felony, the 2 felonies.
That is a correct recitation of the plea, Your Honor.
All right. Ms. Johnson, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
My name is Teresa.
Oh, no.
No middle name Johnson.
All right. Okay. Ma'am, it is this court's understanding you're going to plead no contest to 6 charges. Is that your understanding?
Yes, sir, it is.
And it's to 3 counts of assault and battery. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. Do you understand that?
Yes, sir, I do.
And also the 3 counts of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, sir, I do.
All right. Do you understand what a no contest plea is?
Barely.
Barely?
Yeah. Will you explain it?
Well, yeah, I could. Did you talk to your attorney about that?
We talked, just as a chit chat, but it's never for my best
Okay.
interest. So it's like
Pardon?
nothing. I say nothing.
No, what were you saying?
I said it's not for my best interest. So we just, agree to disagree.
Okay.
I mean,
So
you
here's
were
what
saying
we're
that to see if I could get time to serve and go home today.
I
I've
did
been
not
here almost a year straight. I got out and went to 3 different places and came back in like less than 2 weeks. Like been here almost like a year straight. So for the same stuff, I was like, I don't understand.
Okay. All right.
Your Honor, may I give some background to this case just for the record?
Sure.
Kelly, thank you. Thank you for the bits. Thank you. Because she's married to Bill. That's why I said that.
These matters, all three matters have been adjourned several times. Public defenders, including Mr. Bellinger, but also some of his colleagues, have worked very hard in getting a good resolution for Ms. Johnson. They've looked at different treatment courts. We have been communicating essentially nonstop on this case. They have beaten me up as much as they possibly will in getting this offer. The offer is not going to approve. With that said, I don't know if the council wants to approach it, we can discuss further, but I just wanted that on the record that this is not something that came about easily. It's not something we would normally just offer right away. And for somebody who has 3 pending cases of these natures, including CSC, assisting obstructing officers, and so on.
Sorry. Oh, I appreciate that, and I do recall that from these files. My concern is not that, or that it's going to improve in any way, but making sure that this defendant understands what she's doing.
Yeah.
I quite frankly believe it was explained. It may not. It's an interesting thing. Sometimes I'm sitting up here talking, but people aren't hearing me. And so that may have been the case here. But based upon the 2 things that she has said on the record, what I'm going to do, if the people will leave the offer open, is I will adjourn this out a couple of weeks. So all of the issues that Ms. Johnson has that council can answer can be clarified.
Your Honor, we'll leave that vote.
I think that'd be the best, Your Honor. Thank you.
All right. So Ms. Johnson, here's what I'm going to do. Your
Okay,
attorneys are going to come see you again. All right.
okay,
And the important
All
thing
right.
is that you listen to what they're telling you. Okay.
okay.
All right.
Been
And
doing
if you have
that, but
questions,
okay.
and hold on, if you have questions and things, you got to make sure to ask them. And then I'm going to adjourn these out 2
Okay.
weeks. We'll come back and hopefully we can get this done. Okay.
Yes, sir.
All right.
Thank you.
you.
You're welcome, Judge Simpson. I appreciate you.
Yes, ma'am.
Thank
Thank
you,
you.
Jay.
Monica, thank
Certainly.
Thank you. Thank you.
So these are adjourned out to the 20th. Court does call the case. Court does call the case of the people versus Daniel Greenwood.
And then on behalf of the people.
Good morning, Your Honor. Good to see you. As always, Robert Ellman with and on behalf of Mr. Greenwood. Mr. Greenwood, can you please state your name for the record?
Daniel Lowell Greenwood.
We're still waiting on a competency.
That's my understanding, Your Honor. I have just been appointed to this matter just this week, but after speaking with Ms. Zenda, I do believe there is some kind of holdup with the competency evaluation.
Yeah, I have a January 7th letter that they're looking at for records. That's the last communication I have.
That's what the people say, Your Honor.
All right.
May I speak, Your Honor? No,
Sure. Go for it.
I am a CIA agent on record with the United States of America. And I noticed some flaws in the paperwork. Where it says arrest date and time, it says at 3 a.m. But where it says time booked, it says midnight. How was I arrested after I was booked? That's a motion for dismissal. That's all I have to say, Your Honor. And I will be
Yeah,
pushing
but-
for wrongful incarceration.
Bill, what do you think about that? Is that a motion for dismissal, Bill?
Pardon?
I will be pushing for wrongful incarceration of a federal agent.
Okay.
Your Honor, Mr. Greenwood did discuss these things with me. I did tell him that we needed to wait for the results of the competency exam before we could move forward. On any of those issues. However, I am,
And your legal assessment of that is correct.
thank you, Your Honor.
You're welcome.
And like I said, I was just appointed. I guess to me, as I could see in the register of actions, it looks like the competency exam was ordered back in potentially July.
It was ordered a while back, and there's issue with some records. So what I'm going to suggest is that we contact the forensic center and try to see if they need a new order. I don't think they do, given the January 7th letter that was sent. I think they just are waiting on something before they can complete the evaluation. So what I will do is I'll adjourn this to March 27th. If we get a report before then, we can of course move up the date.
Thank you, Your Honor.
Competence hearing March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day, Mr. Green.
Okay, so this stream was definitely before March 27th, 2025. Right, Bill? They were asking when you did this stream, but you didn't answer them. So now I'm trying to piece it together.
Have a great day, Your Honor.
There we go. I'll take it off mute today. Judge Simpson did his best to hold it in. I'm proud of him for it. I wouldn't have been able to hold it in so well.
Me neither. I know he did because that guy was clearly crazy, right? Do you agree?
Welcome to American Courts. It's been a little while since we've done an evening show, so welcome everybody. We got Kathy here. We got Terry, John, Nan, Eileen, John the Beagle Dad. I think we got a little bit of everybody. We're going to jump over to, I got Judge Simmons and another Judge Simpson one. Has everybody seen the Judge Norbeck one with the lawyer trying to be a judge lady crying over a ticket?
No, wait. Before you have to answer some of my questions before you ask a question. We have questions from the audience here, and you're not. Why are you saying this is nighttime? This isn't nighttime. This is early in the morning. Bill, are you confused? It's 4:30 a.m. It's fine. It's 4:30 a.m., so he's not awake yet. That's why if he says stuff that makes it sound like it's at night, he's just still asleep.
Let me know in the comments if you had. I got it from people in court, and I'd love to show it, but I want to make sure that everybody hadn't watched it 30 times. So let's jump over to Judge Simmons and Simpson.
On the record in the matter of Joe Ella Chambers versus Lynette Farr, 23-02425. Appearance, please.
Good afternoon, Your Honor. Brian Butchart. I'm appearing on behalf of the defendant and counter plaintiff, Ms. Farr and Riverfront Apartments.
Okay, ma'am, please state your name.
Excuse me, Joe Ella Chambers.
Okay, I do see that Ms. Chambers filed a answer, which is in the file. Counsel, did you get a copy of that?
I did, Your Honor, yes.
Okay, and then my note was that she was to file an answer and a more definite statement and counter complaint within 2 weeks. Let's see. Okay, and then the other issue I had was that you had not hired an attorney, but you were at some point at least looking to hire an attorney. You still have not hired an attorney, correct, ma'am?
I mean, let's
I can't hear you, ma'am.
I've tried, I've continuously tried.
Okay.
I've spoken to several attorneys. Do things.
If I can't hear you, I can only imagine that he can't hear you.
Neither can I. But guys, I have a question. If I point right there, so cameras get reversed a lot and I don't see it here. That's why I'm asking this stupid question. If I point right there, am I pointing at American Courts? The words. If I point down there, am I pointing at Bill? If I point right there, am I pointing at the comments that are at the top of the screen? Or am I reversed?
Sorry.
We can't hear you, ma'am.
Man.
Straining to talk as it is.
I understand.
But I've tried to retain counsel quite some time. Different. I can't get a lawyer.
Okay.
I can't get it.
Okay, so you're gonna proceed on your own in this matter then?
Yes, ma'am.
Okay, And then counsel for the defense, I think did we attempt before to have a pretrial on this?
But Your Honor, I know that my partner who initially had this case has attempted to speak with Ms. Chambers on a couple of occasions, and it just doesn't appear like it's going to be resolved. I guess I would like to make a brief argument if and when the court permits regarding the answer that was filed and the lack of a more definite statement as ordered. But I don't think pre-trying this is going to help at this point, Judge.
Okay, yeah, you can make that argument at this time.
Thank you, Your Honor. As you did indicate, when we were before you 2 weeks ago, the plaintiff was ordered to, of course, answer the counter complaint as well as file a more definite statement. As noted, she did file an answer on a civil answer form. We started that answer with the statement that she was answering the complaint, or I think she, of course, intended the counter complaint. But she went on, it's obviously not responsive as required by the court rules to the counter complaint. There, she specifically required pursuant to MCR 4.201, I'm sorry, MCR 2.111C, to answer each allegation individually with either an admission or a denial. She's failed to do that. It's a 3-page run-on narrative. In it, there also appears to be additional claims that were not claimed in the original lawsuit. She's claimed, I think, an additional $2,055,000 in accumulated damages. So I don't believe that the answer is compliant with the court rule or the court's order, nor has she filed the more definite statement as ordered. Your Honor, at this time, I would request that her case in chief be dismissed. I do understand that she's not an attorney, that she's proceeding in pro per, but this court has given her a lot of opportunities to comply, and as a matter of fact, she is required still to comply with the court rules, even though we do know that she likely doesn't understand them fully. I think the court's given her plenty of opportunity. We still don't quite understand what exactly her complaint is about. I think this is our 4th appearance before you, Your Honor, and at this time we would be asking the court to dismiss her matter.
To the extent that I'm going to give you an opportunity to respond. I did order that you file a more definite statement. I only see an answer to counter complaint, which was filed 2 days ago. And for the record, this is the first time I've seen this file since then. So I've not had an opportunity to read this. Where is your more definite statement?
Again, Your Honor, I was homeless.
And that's not what I asked. That's not what I asked you. Where's the more definite statement? Because on the 23rd, I said that you had until now to file a more definite statement. Where is it? You've not filed one?
I haven't.
Okay. I'm
trying to find a place to live.
I understand that, but you're the one who's bringing this lawsuit. They didn't haul you into court while you were trying to find a place to live. You hauled them into court. So you're still responsible for following the court rules and the procedure. And I can't deviate from that because of your own circumstance. When you brought this matter before the court, you didn't have to bring this matter before the court if it was something that you could not move forward with appropriately. And even if you can't get an attorney, you filed this complaint on your own. You are still responsible for moving the case forward in an appropriate manner. It does say at the top under the address counter, so I'm assuming this is the answer to the counter complaint. I got to dismiss your complaint for failure to prosecute because you have not essentially put enough information in the complaint to put the defendant on notice as to what you're suing them for. So when I ask for a more definite statement, that's what I mean. You're required by the court rules to put the other party on notice in your writing specifically of what you're saying they did to cause you damage, that they had a duty and that they breached of. So you've not been able to do that. I'm going to dismiss the case, but it will be dismissed without prejudice. So that means you can reissue the lawsuit at another time appropriately, and if you get an attorney. But as it relates right now, it's not moving forward, so I have to dismiss that. As to the counter complaint, I gave you an opportunity to address the counter complaint. The counter complaint, your answer is about 5 pages long, and I don't know that it's sufficiently, without reading it, is addressing the counterpoint, because even as I skim it, I see issues about police and civil rights, and you're requesting $2 million. And if you're requesting $2 million, you're in the wrong court.
No, now,
You know what now?
I'm in the wrong court.
You can't get $2 million out of this court.
I'm getting false information, I'm getting held up, I'm getting
Who's-
blocked everywhere.
Who's
I
holding you
turn.
up?
I come to the courts, I ask people, I've never been in a city where they give you the wrong information, mislead you on everything.
Well, we're not holding up your
I'm not-
case, and the court is not to give you legal.
Okay, on a scale of 1 to 2, 2 being really mad, how mad is Bill gonna be at me? On a scale of 1 to 2, how mad is Bill gonna be at me? Somebody tell him. Don't anybody tell on me, okay?
Advice.
No, ma'am, I'm
So,
not saying.
so you're the one who's bringing the lawsuit, ma'am. You understand that?
Sometimes I understand, I have a headache, I have a hope, and I get confused in terms.
I can understand that. And so what I would advise, ma'am, is that you probably not try to bring this lawsuit on your own, maybe get some assistance of a counsel, an attorney. Because it's not clear what you're suing for, okay?
I'm not saying she doesn't do small claims, but this is usually criminal court. But this could be small claims today. You know how judges are.
Saying that there was damages. And I'm simply saying, how can there be damages when she is falsely using my apartment?
Who is she?
Lynette Farr. She would say first of all, it's $585. That's the exact amount of rent. That's the exact amount I charge them with stealing. That's all on police records. That's all on record. Second of all, she was using my apartment to show investors, and she's sending me letters like they're inspections. It was her own workers who told me she was using my apartment as, to show investors. My apartment's in immaculate condition. All they did was come in there and steal.
You have pictures of the damages?
I have pictures.
I'm talking to Mr. Burkhardt, sorry.
Your Honor, if the court's going to dismiss her case in chief, my client doesn't want to be in court, Judge. I have authority to dismiss our counter complaint. We brought the counter complaint.
I'll accept your dismissal of the counterclaim. We'll issue a dismissal on both sides. And we'll note that you are dismissing the counter complaint. The court's dismissing the complaint for failure to prosecute.
Good. Case dismissed. I'm not scared of Bill. But Emily, though, let me tell you, if she gets mad at me, I'm in big trouble. I'm gonna need to hide. Me too, Linus. Just so you know, me too.
And
I'm gonna go get coffee.
Dismissed
I'll be right
without
back.
prejudice, okay?
Be good,
Thank you, Your Honor.
guys.
And I'm sorry, did you wish for me to submit that dismissal on the counterclaim?
Yes, please.
Okay, will do.
Do you have any questions, ma'am? Okay, good luck to you if you do intend to refile this with counsel, okay?
Thank you, Your Honor.
Thank you.
All right.
I saw you on TV.
You what?
I saw you on TV.
No, that was my cousin. Thank you, sir.
The other thing to potentially address is there's a bond violation report
Yes,
that
there is.
I certainly would love to address. He has, the last time we were here, we had also talked about him getting employment. To my knowledge, he has a job, and to my knowledge, he also is getting a paycheck on Thursday. He reports to me that he would, if he were to test, and I had that conversation with him just now, that he would pass any alcohol or drug test. He would have the funds to start testing today. And if he were to test today, it would be no violation of any sort. So with that, I'd like to get him to community corrections within 24 hours to make that initial test. And I would like him
He's
to.
missed 4 in a row.
I understand that, but he's had some financial difficulties.
Yes, sir.
I didn't have the money the whole time, sir, because I basically, once I start the job, I don't get paid until 3 weeks after, until after the job, or not until after the job, but after the start date, sir.
So
It's the first check.
you read the report, right?
Yes, Your Honor.
He goes over, he says he doesn't have that, but then says that he would borrow the money from his aunt in return,
I tried, and she didn't have it,
and
sir.
he didn't return. And he didn't submit to any tests, and he didn't call him back either.
Sir, I was actually trying to stay in contact with my attorney and actually have a bunch of phone calls, which my wife, my fiance does have on her right now that
Hold on,
I didn't get any.
sir. You didn't go, why didn't you call him back?
He's talking about community corrections.
Because I was trying to get a hold of my attorney to figure out if I can get a hold of you, trying to see if I couldn't get the fines waived, sir. That's all. I was trying to see if I couldn't, because I don't have no problem dropping. I just didn't have the money at the time, sir. So I was trying to get a hold of my attorney because I was trying to get him addressed where, like, to get a hold of you to see if possibly I could get those fees waived until I got my paycheck. And I'd have paid it all at once. That's all, sir. I promise I wasn't trying to evade or anything like that. That's why I was trying to stay in contact with my attorney, but he was busy this whole time pretty much.
Your Honor, last time we were here, I also addressed that he had walked himself in on this case. He had also walked in, there was a child support order. He's working to try and get in a direction to where he can start taking care of this case and a previous child support warrant. So the fact that he is employed and has a job, I'm asking that he can continue in that job and not.
Right, but the problem, the difficulty I'm having here is I amend the community corrections order. I release him on the 23rd, I think it was.
Yes, sir.
He's supposed to test, told him he was supposed to test, and now I'm here. That was on January, when was it? No, that was, yeah, on January 23rd. Now here, first part of September, and I don't have a test at all. I don't have not one.
I sorry, sir, and I promise it won't happen again. I really would appreciate this one more chance so I can go do this because now I finally have now I have the money for it. Is all. That's all. I'm just asking for one more shot, sir. And I will not let you down.
I don't understand why you didn't call them back. You went in, said you didn't have it.
Yeah, because I asked her, but prior to that, I had asked her if any way I can get these fees waived. And she said, no, I had to pay this every time I drop. So that's why, sir. I tried to get it that day. I couldn't get it. So then after that, literally that same day, I tried to contact my attorney to see if there was anything we could do before this date even happened so I can get back on the track to drop again. That's all, sir.
Having a hard time believing.
Your Honor, I mean, it's strictly a financial issue.
I
for
get
him.
that part of the issue. What I don't get is why he didn't call community corrections back after he said he was gonna borrow the money. Then community corrections gets no call.
You're right, sir. And I do apologize. You're right.
No call whatsoever from him.
You're 100% right, sir. And that's my fault. And I do apologize. That'll never happen again.
I think it would be nice to get a baseline to find out if he's telling the truth on whether or not how he would test.
I get it, but I'm now 2 weeks down the road
Mhm.
without a test. And I let him out on his promise he was gonna go test.
Perhaps it would be appropriate that
And
during it
go
1
ahead.
week, have him test within 24 hours and come back. and
Well,
see where
I
things are.
don't. What would be appropriate is he's violated a court order and he should be remanded. That's what's appropriate.
I'd like to fight hard for this gentleman right here who is employed. He's getting a paycheck on Thursday. He's going to have the financial means to continue to test pursuant to the court order 2 times a week.
You have the money to test today?
Yes, sir, I do. Yes, sir, I do.
I ought to lock you up.
And I wouldn't blame you, sir, because I did mess up. And I do apologize. I was really just trying to get a hold of my attorney. And it does sound dumb. I do understand, sir.
I can understand you getting a hold of your attorney. I get that. But you didn't even pay the courtesy to the people at Community Corrections to call them back.
Yes, sir. And I do understand now. I would promise you, if you give me this one last shot, I will not break it. And
I'm
I,
gonna tell you what, I'm gonna give it to you. I'm gonna do a new Community Corrections order, standard supervision. You are to test today.
yes, sir.
If a dirty test come back, you miss a test or anything along
Fletcher's
those lines,
here.
I don't want to hear anything. You're going.
Absolutely, sir. I
Bill.
promise I won't give you any excuse.
Bill, look, Fletcher's here. Bill. He must still be tired, guys. He's ignoring me.
I won't. I got a lot of people to pin.
It'll be adjourned to February 13th, 2025, 9 a.m. 1 week. And you better hope he's clean.
I will be, sir. I promise.
You know what? You need to be quiet.
Thank you, Your Honor. I have this form.
And thank that man next to you, because quite frankly, my customary practice would be to send you.
So, and regarding the, obviously, I really do hope for a quick turnaround on the video, but I'm not sure. It may.
Well, we may have to turn it out, but you've got big problems because I want to make sure I get a test. You are to go over there right now.
Right this
Thank you,
second.
First cause case, people versus
I don't
Fabian
listen,
Herrera.
Jude. I don't know, but it looks like once you said strippers, he had a tiny smile. Don't tell Emily. She'll get him.
You state your name for the judge, please.
Yes, Your Honor. My name is Fabian David Herrera. Thank you.
Sir. Your Honor, I'm asking for a 2-week adjournment. There's some surveillance videos that we'd like to get.
I missed Bill. So this is his old stream that I'm just playing because we missed Bill. So we are watching, you guys are watching a video of me watching a video of Bill watching court videos. That's what's happening this morning.
It as well as body cam. And then I'd like to address bond as well. Please.
February 20th, 2025, 9 a.m. Esteban.
Your Honor, it's my understanding you had a personal bond. There was some sort of bond violation, but I have not received any paperwork on that. So I'm not sure where that stands, but I would be asking for a bond to be reinstated.
Well, why would I do that?
I'm not sure. I was under the impression that is a personal $5,000 bond. And a few days ago, my client was at the hospital and got arrested for some reason. He wasn't sure why, but then he ended up.
Like no use of alcohol, maybe?
That could be.
That could be.
That could be. So
maybe you want to see the report before you make the request to have his bond changed. But at this time, I'll deny your request to change his bond. Bond will continue. Thank you.
Okay. Thank you, Judge. Your Honor, briefly, could he be placed on a tether and released on a personal bond? We've got several compelling reasons, I believe.
So I just what?
You said no bond. I just wanted to make a brief request for the record.
Okay, and for the record.
For the record, one thing you can be sure of is live stream every morning near 4:30. Everything else, I do OJ right after for right now, but that's going to end in a bit. And then I don't know if I don't think I'm going to fill that spot with another live stream because numbers are really bad and they're killing all my other work. So after OJ is done, that second live stream will go away, which opens up time for me to do maybe something else, maybe a nighttime quick live stream, like 30-40-minute live stream every night. Who knows? I don't know, but it's a while away. But you can be sure an hour before right now is around 4:30. Sorry, I was screaming so much yesterday. I need to stop talking. But that's what you can be sure of. Every morning I'll stream.
Heard that is also denied.
All right. Thank you, Your Honor. Have a good
Thank you,
Your Honor,
I'll
with
have
regard-
some information over shortly.
Your Honor, with regard to the bond in my case, I believe, I don't know if Mr. Bowling is going to address bond in yours.
I wasn't prepared to. Your Honor, in my case, my client had a head bond and he posted he was out, obviously. And then he missed a court date on January 2nd. And so the court canceled his bond, issued a bench warrant. My client indicated to me that he did not receive notice of the hearing. It was set for January 2nd because apparently because of the holidays, he did not get notice, and that is why he did not appear.
Who was representing him before?
I've been representing him in this case straight through. I not represented him on the new case.
Yara, may I respond?
Yes, go ahead.
It is my understanding that
It says Godiva. It's a Godiva cup. It is the chocolate that we have here. I don't know if you have that there. We have some delicious chocolate here, Godiva chocolate. And this is a great big Godiva coffee mug from my Godiva chocolate.
in addition to the failure to appear, at the time of that failure to appear, the defendant had a community corrections violation for not testing.
Were you aware of that, Mr. Golson?
No, Your Honor.
Pardon?
No, Your Honor. We don't get community corrections violations very often. I know that at one point, Your Honor, he was in treatment. He did contact me and tell me he was in treatment.
Right, but so what happened is
I'll
that
drink many of those today, many.
in November, he tested positive for cocaine, and then I don't get another test from him at all. I'm gonna death farm.
That may have been when he was in Don Farms, Your Honor.
I have motion for bond reduction denied, bond will continue. But
Judge, my client wants to address you about his tether.
Fine.
Apologies.
Mm-hmm.
You want me to do it?
Yeah, the plaintiff in this case and I share a 10-year-old son. We co-parent a 10-year-old son. We have no issues.
All right,
And
I'll take it from there.
Okay.
So what I think he's asking, Judge, is he wants to be able to get back to being able to do exchanges with the child and the parent, their 10-year-old child. I believe the complaining witness is present in the courtroom, and he's asking if the court would consider allowing them to have a contact order so that they can get back.
I think we all missed it, but Bill was just smiling, guys. Bill, he's the one down in the other corner. If you don't know who Bill is, he's down in the corner. He's very, very loud. And he pauses too damn much to talk. Well, everybody needs coffee, but Bill was just smiling, I think. Right, Bill?
To being able to exchange the child and take the child to school.
do the people have a position or
I'll leave it in the court's discretion.
has so the prosecutor, have you guys talked to the victim in this case or?
Yeah.
All right.
She is present here, Your Honor. I did speak to her, and she has also asked me for contact, Your Honor.
Okay, where is she?
She's right here.
All right. Come on up. Don't be shy.
How old is she, Cher?
Take this.
Hello.
Hi,
What's your name?
Jessica.
All right. And you wish to have
Bill, that was unacceptable. That was out of pocket. And that was really mean, Bill. Bill. When Mr. Allen walks across the camera, you don't cut it at that point. You don't cut it at that point and then fast forward, Bill. That hurt my heart.
contact?
Yes, it's a big misunderstanding. It went too far and I just want all this to be over it.
All right. Well, the case is set for prelim, but you feel secure that if I were to allow contact.
I am
and there's-
perfectly safe, yes.
And there's a child that also kind of needs both of you.
Mm-hmm.
Telling me.
Yeah.
Okay. All right. Anything else you want to tell me?
Can I tell you what happened?
No.
No? Okay.
No.
All right, that's it.
No, I don't. Judge Washington will be more than happy to hear that.
Okay.
I've heard enough today.
Okay.
All right. Thank you.
I believe that we'll tether on our client to make sure he does not go to the address in place.
Got it. Okay. So So it was an exclusion zone tether.
That's
That
what,
was this. Okay. So what I will do, that's why I think we can do an order, is I'll delete the no contact and we'll change that to no non-consensual contact. Okay. So sir, what that means is that if it's okay to have contact, but if for whatever reason she doesn't want to have contact with you, you gotta go. Got it?
understand.
Okay. And then I think we will delete the no go to. And then the defendant can be removed from the tether.
Thank you very much.
Thank you very much.
Thank you.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Pittman. Mr. Pittman may have called in, Your Honor. He did contact our office this
No,
morning.
he's here. He's right there.
I'm here. Hello, good morning.
Good morning.
Your Honorable Judge Simpson, how are you today?
I'm doing fantastic, Mr. Pittman. Thank you for asking.
Not a problem.
You here.
Well, good. Your Honor, Mr. Pittman has a Secretary of State appointment on the 18th. We are seeking a date after that, so we can be working on getting its license.
Okay, so his appointment with the Secretary of State's on the 18th.
Yes.
All right, why don't I do this? I'll adjourn the matter to March 19th, 2025, 9 a.m. as your invite indicates. All right, sir?
All right. Hey, Judge Simpson, I have a question for you off the record.
Well, I'm on the record, but go ahead.
I have a shirt made for you, and I make shirts, and I wanted to know when I can drop this shirt off to you.
Does it say filthy animal?
Well, typically, I'm not allowed to accept gifts, sir.
Oh,
So,
okay.
Is that the shirt?
okay.
It has your slogan, Rock Out Judge Simpson.
It says what?
Rock Out Judge Simpson.
Well, I can't accept it, but certainly I'd love to see that.
No problem, Judge Simpson. I'll make sure I'll get it to you.
Thank you, sir.
No doubt. See you later.
Take care.
Yep.
All right, everybody. I'm going to jump over to People in Court. She had a good video with Judge Norbeck the other day. A lawyer trying to run for judge got a ticket for sliding off the road in the ice, and she wanted to debate it. So we get to see what a professional does and how a professional handles getting a ticket.
Okay.
Yes.
I do not have this specific link to this video that he is showing from People in Court. But People in Court is great. And it's so freaking professional. I mean, if you want to watch, there's no muting and talking, don't worry. If you want to watch a professional do court videos, I'm an idiot. This is the channel to go to. And now, Bill. Now we are going to watch Bill. All right, you guys are watching me watch Bill watch People in Court watching a court video. And here we go.
Canfield Cadbury, you can hear me, right?
Yes, I can.
All right. This is a citation that was issued on January 10th of this year on US 131 there in Wayland Township. Said too fast for conditions involving an accident.
So there's the lady there running for judge. So she's got her stuff together and she's going to be a judge. She's going to make the best decision. So here we go.
Hear me, I'm on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight this ticket at what we call informal hearing. What were you looking to do?
I want the hearing, please. I deny responsibility.
All right. Then the first thing I do is swear you both in. You want to go ahead and raise your right hands. You swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
Yes, sir.
All right. Ma'am, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place, but then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Yes. Can I just state something for the record first before we begin?
Sure.
The only thing that I wanted to state is that I did previously request an adjournment of this because I did suffer a head injury and I am written off from work because of my head injury by a concussion doctor at the neurology center at Bronson. I'm not supposed to be practicing law, so I don't feel that I should have to go forward. But I was told by the court we could not adjourn this unless I wanted to have a formal hearing and skip this process. So I just—
That is correct.
I
If
wanted—
you don't want to go forward today, you can ask for formal hearing. That'll get reset and they'd be compliant with you asking for a date considerably farther out. But for informal hearing, we don't move dates, either by officer or by defendant.
Yeah, I just wanted the court to be aware that my processing right now is slower. And so I might take a moment to ask questions and things.
That's fine. We have time.
Thank you.
All right. And so with that, Deputy, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation?
Yes, sir. So on January 10th, 2025, shortly after 5:04 p.m., we were dispatched to southbound US 131, just south of the 6-1 mile marker on ramp, for one vehicle crashed into the ditch. Upon arriving on scene, we found a single vehicle identified as a 2016 Chevy, red in color, with the attached Michigan license plate of Edward Lincoln David 430, into the right-hand shoulder of southbound US 131. Through investigation, I found that the vehicle was traveling southbound when it had lost control, went into the ditch, and did sustain damage. I did issue the driver and the only occupant of the vehicle identified as Angelique, and I don't know if I'm pronouncing that right, Angelique Camfield Kuiper, the citation for the violation.
Angelique. Nan, Bill, what do you think? Will she have trouble being a judge if she has a head injury, or will she fit right in? Is that sort of a prerequisite?
Violation of the basic speed law for driving too fast. I did issue her citation SD 33604.
All right. And Ms. Camfield Kuiper, what is it you wish to tell me?
I would like to cross-examine the deputy, please.
Okay.
And Deputy Earl, how long have you been a deputy for the Allegan County Sheriff's Department?
I've been here for 2.5 years.
Any prior law enforcement experience?
Yes, ma'am. I've been an officer prior to that for a separate agency for a year and a half.
When did you graduate the academy?
I believe it was 2020.
And what—
Ms. Camfield Kuiper, how would this be relevant to your citation?
I think I have the right to ask him his background and experience to determine whether I was going too fast when there was no
Ma'am,
personal observation.
Then let me just put something on record here. This is not a speeding ticket. It's not accusing you of speeding. You can get this ticket going 10 miles an hour. What it is you have a duty to maintain your vehicle on the roadway. Weather conditions and road conditions are not a legal defense to this ticket. Essentially, the only legal defense to this ticket is I didn't slide off the road. So I'll let you proceed, but what the officer's experience is not relevant. He's not making a judgment call that you were too fast for conditions. He's simply observing that your car left the roadway. That is the only element to this citation.
Actually, Your Honor, I looked up the statute, and the statute says exactly, it is under the speeding statute under 257-627 parens 1 that I.
Yes, ma'am, but like I said, if you're going 10 miles an hour and you slide off the roadway, you will still get this citation. It is not accusing you of speeding. It is accusing you of going too fast for conditions. The prima facie evidence of that is that you left the roadway. But
Well,
you can
I
continue.
respectfully disagree with the court on that. Deputy, did you personally observe any of my driving that day?
No,
Did you speak to anybody who personally observed my driving that day?
no, ma'am.
Can you tell me what the weather conditions were that day?
I believe they were cloudy with snow.
Can you tell me where you were when you were dispatched to the scene?
I believe I was in Wayland when I was dispatched to this scene.
Do you know what the distance was that you were away from where my car was?
I do not.
Do you know how long it took you to get there?
Like, living in Pennsylvania, if we got tickets for driving off the road when there was ice on the road, we would all be broke. Every one of us, even the ones who don't drive, would be, right, Bill? Bill, in Florida, do you have that? Bill, in Florida, do you have that problem? Do we drive off the road in the ice storms?
I do not.
Do you know if the snow began earlier in the morning and was accumulating on the highway?
I do not recall.
Do you know if it was icy in addition to being snowy that day?
I do not recall.
Did you have an opportunity to review your accident report prior to testifying today?
Yes, ma'am.
Do you recall on your accident report that you wrote there was no ambulance at the scene?
I do not recall.
Would you refresh your recollection if you saw your accident report?
Yes, ma'am.
Do you have that with you, sir?
Yes, I can pull it up.
Could you take a look at that, please, and tell me whether you marked an ambulance was present or not?
Ma'am, can you tell me whether or not it would be relevant, whether or not there was an ambulance there?
Yes, Your Honor, if the deputy can't recall what the weather was, how long it took him to get there, whether it was icy in addition to snowing, and there are errors in the traffic report, it calls into question the veracity in his recollection with respect to that day.
Okay, but ma'am, the relevant sentence would be your testimony of whether, are you denying that you had an accident and left the roadway?
No, Your Honor, but I have
That's
other.
the only pertinent question.
I have other information to present to the court.
Okay, why don't we present it in the form of testimony as opposed to cross-examination, and I'll determine whether or not this line of inquiry is relevant to a civil infraction.
Judge Ito, Judge Ito, just saying you could have done something like this months ago in that OJ trial. I'm not mad. I'm just sorry.
Yeah.
Traumatized. Sorry.
Okay. I guess I don't.
Ma'am, let me put it another way. Road conditions and weather conditions are not a legal defense to this ticket. You have a ticket that says your car left the roadway. Do you have any information to present that your car didn't leave the roadway?
No, the statutory section says, did I operate at a careful and prudent speed, not greater than nor less than what's reasonable and proper, having due regard to the traffic surface width of the highway and any other condition existing.
I'm really not asking you to. Don't. I'm not asking you to. Don't. I'm just saying It would be freaking hilarious. Don't. I'm not asking you to. I'm making a joke right now. It would be freaking hilarious if I got a whole bunch of money from this stream. Come on, wouldn't that be so funny? Right, Bill? Bill! Bill! Wouldn't that be hilarious, Bill? Wouldn't you be so happy for me? Wouldn't you be so proud of me, Bill?
Definitely familiar with the statute. Here's the issue. The testimony is that your car left the roadway. That is the prima facie evidence that you were not traveling at a speed conducive to the weather conditions and the road conditions. Ma'am, you can make that argument, but what I need to hear before I make a ruling, is we're getting way far afield of the information I need, is whether or not you had an accident where you left the roadway that day. And I have testimony that you did. If you would like to provide testimony that that didn't happen, that would be relevant for this citation.
So none of the road or weather conditions are relevant to this action?
No, ma'am. I sit here all winter, every year, getting this citation. If you have a slide off, even a one-car slide off, you will get this citation. We cannot give a ticket to the road for being icy or to the weather for being snowy. We live in Michigan.
But
people were driving all day long on 131 and not having accidents, but you had an accident. That's why you have this citation. The defense to this citation would be, I didn't have an accident.
Well, I don't.
You cannot blame it on the road or blame it on the weather. That is not an option for me to not find you responsible. I would still find you responsible regardless of the weather or regardless of the road conditions. You always theoretically could have been driving differently and not had an accident.
And
right?
the court is predisposed to a decision on these tickets.
Well, no, ma'am, because I would be willing to hear you say that didn't happen. I didn't slide off the road. But you're not suggesting that or testifying that. You just are going in circles about road conditions and weather conditions. So what I'm saying is I give you an opportunity right now to present to me relevant testimony to my decision of whether or not you had a slide off that day.
The relevant testimony, Your Honor, is that I was traveling at a careful and prudent speed. And
no, you weren't, ma'am. Otherwise, you wouldn't have had an accident. That is the definition of careful and prudent, right?
I disagree with the court.
Okay.
If I may
So,
testify, I would appreciate doing so.
Go ahead.
Thank you.
Kelly,
I work
thank
in
you,
Grand
thank you,
Rapids
thank
and
you.
I live in
Thank you,
Kalamazoo,
Kelly.
Michigan, and I was on my way home from work. And you'll have to forgive me. This when I talk about this accident, it's very traumatic and it makes me extremely upset. I haven't had a citation in over 20 plus years. My last ticket was when I was in my 20s on my way to law school.
Ma'am, again, that's a relevancy issue. It would be unfair of me if I looked up your record and made decisions on.
Listen, we have to give Bill a second to pull himself together because this is really sad. And I don't want Bill to be sad. Bill, are you okay? Bill, talk to me if you're okay. Please, Bill.
This case based upon whether you did or did not have tickets. All I have to do is decide on January 10th of this year around 5:04 p.m. did you slide off a 131 or not? That's the only thing I have to decide. I already have evidence provided from the deputy that that did in fact happen. This is your opportunity to present evidence to me that it didn't happen.
Well, I was driving at a careful and prudent speed, which is part of the statute. And just that the fact that my car went off the roadway does not mean that I was not. There were 22 accidents between mine and the hospital the EMTs were taking me to. They told me that. And it wasn't that every single person was driving too fast for condition. I had just driven. So when I left my office, it took me 20 minutes to clear off my car. I'm
Yes,
very, very
thank
careful to
you,
make
thank
sure that my
you.
lights aren't covered. There's no snow on my roof or anywhere else. My plate is visible. I'm very careful with that. And I had just driven through an accident. I don't have a clear recollection, but it was either just at the south end of the S curve or towards Caledonia. And I was being very cautious because I was trying to get home safely and have a weekend with my daughter because her sister was out of the state at a soccer tournament and I just wanted some time with her. And I remember that I texted over the Bluetooth, my staff at the office, and I said, be very careful, the roads are bad. And then I called my daughter over the Bluetooth and said, honey, I'm gonna be late because the roads are really, really bad and I just passed an accident and I'm taking my time.
Ma'am, I'm gonna caution you. Did you just testify that while you were driving, you texted?
Over the Bluetooth, it's the voice to text.
All right.
I do not hold my phone while I'm driving ever, and I always wear my seatbelt.
Absolutely, yes, yes.
So I let them know that I was gonna be later because I was taking my time and being cautious. When I got into Allegan County, the roads were worse and the visibility was lower. And I'm hesitant always to change lanes in that weather because in Allegan County in particular, the road commission's really bad at clearing the roads.
Are the antibiotics working? You should know by now if they're working, right?
I've driven in this state. I've lived in this state my whole life. I know how to drive in the winter and to be cautious. And there was,
Bonjour.
I was hit on I-94 in 2021. I was
Ma'am, you are telling a very long and involved story that is irrelevant to the decision I have to make today.
I'm trying to explain what happened.
How is anything that you've told me so far going to explain whether or not you left the roadway or not?
Because it tells you how it
thank you so
happened.
much. Thank you.
I was being careful.
No, it doesn't, ma'am. The
Driving.
fact that you were in an accident in the past on a different road has no bearing on what's happening here.
It does because I was rear-ended and slammed into the vehicle in front of me and it caused me trauma. And there was somebody that was coming up really fast behind me, probably a truck, I can't remember. Because I get
I never
really
stopped.
nervous then when they're behind me so fast because I've already been hit. So I slowed even more and wanted to put my indicator on and checked my mirror to make sure it was clear. And I started to merge over so I would get out of that person's way. And then the slush was pretty deep. It was about maybe 3 or 4 inches
I love
of
your
slush
bits.
between the lanes.
I love
and it
them.
caught my tires. And there wasn't anything that I could do. I wasn't driving too fast. I was trying to slow down even
Kelly,
more
thank you. Thank you, Kelly. Thank you. Thank you.
and get out of that person's way. I'm very careful on the road.
Anything further you wish to tell me, ma'am?
Just that I don't think a preponderance of the evidence demonstrates just because I was off the road that means I wasn't driving carefully and prudently. I was even informing people how bad it was and saying to be careful.
Okay, ma'am, so for purposes of informal hearing, I would find that the deputy has met their burden and that you are responsible on this citation. Now, because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing. Formal hearing is in front of the district court judges. It involves the prosecutor's office. But to get to formal hearing, you must do two things. First is you must ask for a formal hearing within 7 days of today's date. That window of opportunity to contest this further closes after 7 days. And two, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I don't know how much the ticket is.
Look at that. Jen gifted 10 memberships. Thank you, Jen. Give Bill memberships. We should all go onto Bill's stream later today and gift 10 memberships. But I can't today. But another day, we should all do that. Some other day soon.
I can tell you that. It's either 110 or 135, depending on whether or not they put the accident on there. $135. So if you come in and post that as bond, and then request that formal hearing within 7 days, you'd get another bite at the apple. I will tell you the problem that formal hearing will also be that road conditions and weather conditions are not a legal defense to this ticket, but you're free to exercise
I'm
your
going
rights.
to on payday.
But we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you.
Thank you, Your Honor.
All right, I'm going to go ahead and hit pause there. That was an amazing, all over a ticket. That was 110, 130. You know, I'll cry over that kind of money if it's for something else, but over a ticket, I just kind of just grumble and pay it. It is kind of a BS ticket though, to get a ticket for just sliding off the road. So, but that's not the way to fight it. You don't go on YouTube and cry about it.
Just to be clear about that whole sliding off the road ticket, they don't normally just give that to people for sliding off the road. But if you get in an accident, if you cause an accident or are in an accident that makes the police come, blah blah blah, they give you that ticket because they have to give you something because you were in an accident. So obviously you weren't driving your car right. So it's not like if you slide off the road in Michigan, they're going to pull you over for that ticket. They won't. But if you get in an accident, if you get in an accident, they're going to charge you for that. 100 some bucks, $20.
All right, let's go look at some Judge Fleischer.
Oh God, I missed
Good
the
morning. You are
judge
Stephanie DeRay.
too. This is too much. This turned from funny and fun to painful. Absolutely painful. Can we do that? Can we watch both Bill and Judge Fleischer? Oh my God, what if Victoria talks? I might end up like that lawyer and start crying. Me and Lena's just gonna be in the corner. We're just gonna be crying. At least Logan's not here. That would have really hurt. At least I didn't go that far back in time. All right. We are watching Bill watch Judge Fleischer. And that's just sad.
Great. You're charged with
I'm
driving
getting
while
coffee. I'll
intoxicated.
be
You're
right
facing
back.
up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Gray, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an interlock for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand? Now, you have a great lawyer listed in Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand?
I do.
Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand?
I do.
All right. So I'm going to have you sign a reset. Victoria, we'll have you get Felicia for your bond conditions, and then you guys are free to go. All right. Thanks, guys.
Right, Judge, next is page 3. Chirino, come on up.
All right. Well, I called him. He didn't answer. So you all are here. We're going to do probable cause. Each of you are charged with racing on a highway. Who's Carlos Gomez? You're Carlos Gomez. Mr. Gomez, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Kasim, you were charged with racing on a highway, and you were charged with unlawful carrying of a weapon. On the weapon case, you're facing up to a year in jail and or a $4,000 fine. On the racing, up to 6 months. As you, Mr. Rios, you're facing up to 6 months in jail and or a $2,000 fine on the racing case. Gentlemen, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
On February 1st, 2025, an officer who was part of a plainclothes traffic crimes task force was near Cross Timbers and East Texas Freeway in Harris County, Texas, where there was known to be a large street takeover group meeting. Officers in plain clothes were conducting a surveillance of the group of cars known to conduct the takeovers. The officer followed members of this group, specifically a gray Camaro, a white Camaro, and another Camaro. Officers witnessed the 3 vehicles slow down to 50 miles per hour and accelerate simultaneously up to speeds well over 125 miles per hour in order to outpace each other. Plainclothes officers were able to keep these vehicles in sight until marked patrol vehicles arrived and conducted traffic stops. Officers pulled over the vehicles and made an arrest.
So each one of them are in cars lined up?
Yes, Judge.
Okay.
Lane 1, lane 2, and lane 3.
Okay. So tell me about the gun on Mr. Kasim's case.
I'm sorry, Judge, what was the?
So Kasim, it's Kasem. While you're looking at, gentlemen, I'm going to find that there's probable cause to go forward with the case. I'm going to tell you now, living in a city as big as Houston without the ability to drive blows. And I am now ordering you as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first thing I'm going to do is I'm going to put you in jail. The next thing I will do is I will take your ability to drive away from you. Do you understand? Not only that, the Texas legislature has made it extremely easy for DAs across the state of Texas to take cars permanently for people who are continuously participate in these activities. And I'm telling you because I've seen it here where people get their $80,000 to $100,000 car seized and taken, and they don't get it back. Do you understand?
Your Honor. And Mr. Kasim admitted to having the handgun in his fanny pack to the officer.
So can you file those conditions on all these gentlemen? Or I guess, let's go through each of them. Do they have Texas driver license?
They all have eligible Texas driver's license.
Great. All right. One more thing, gentlemen. You are not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, then you're not allowed to drive. If I find that you drive without car insurance or you violate any of these conditions, I will put you in jail. I will do everything in my power to protect my community. Imagine you hit something at 125 miles an hour. You crush anything. Do you understand?
Yes, Your Honor.
I will have you each take a seat while we craft your bond conditions. We'll have you sign it. Because you guys have lawyers, I will waive your appearances. So you don't have to waste your time coming to court, but you must stay in touch with counsel and they will tell you when you have to come back to court. If they tell me they cannot get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for your arrest. You become a danger to my community, I will issue a warrant for your arrest. Understand?
Yes, Your Honor.
All right. I'm gonna have you each go to Victoria Sign and Reset, and then we'll have you take a seat in the jury box.
Gomez?
And then Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
Do not have a story about them, right? On 4/12/2023, officers were dispatched to a crash involving a bus and a car at 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol and breath, SS, and slurred speech and incoherent speech. Defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. Defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant and there was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a point.
I was getting OJ ready. Did I miss anything? If someone said anything, I was getting OJ ready and I missed it.
Yeah, 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm
Bill, Tona's leaving. Say goodbye. Bill. Bill, Tona, just say goodbye. You're not gonna say goodbye. I'm really, really sorry about him today. I don't know what's going on.
now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please?
Monica, thank you, thank you, thank you. I'm scrolling up.
Do you have the ability to hire lawyers?
Going so
sir?
fast.
How much time can I pass this? Because I'm in the process of getting my ID and everything, because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay, so understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm gonna randomly test you. And you're gonna have, you show a Texas driver license? Okay. All right, sir. So what I'm gonna have you do now is I'm gonna have you sign a bunch of paperwork with Victoria, Felicia, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, sorry, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle and the officer was performing a felony stop on the possible stolen vehicle with multiple items in her hand. And the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of. The defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the vehicle, to which the defendant refused and had to be escorted.
It's the voice, like every time he talks, it's like a gut punch. I remember him. I remember that.
By force. The defendant kept moving her hands away from the officer and he attempted to handcuff her again. The officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
She the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop, ma'am. Don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm gonna find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. You understand? Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it and then we can appoint you someone later today. Do not leave until you sign our bond conditions though, ma'am. All right? Okay, please.
This position said
Do you miss being Fozzie's pants? Be honest. Be honest. Do you miss very, very much being Fozzie's pants? We sort of miss it because it was very funny.
All right, quiet in the courtroom. We're going on the record.
I'm sorry, Judge. Jeesh. Jeesh. I'm in my living room, sir.
Ready, Ramona?
Yes, ma'am.
All right. We are on the record. Today's date is February 7th, 2025. It is approximately 10:35 in the morning. We're here on a Faizan Noor Kabir, cause number 215-8240. Guys, would you announce yourselves for the purpose of the record? State.
For the state, Kelsey Seabrook. For the state, Mackenzie Walton.
State defense.
For the defense, Andrew Salinas, Salinas.
All right. And we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are. Appear in court every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court,
No drugs, no alcohol. Applying to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a scram analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So,
Yes.
yes, so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that we're saying that the fees are waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving.
If you're confused, you have every right to be. But I miss Bill. I miss Bill, so I reached back into his channel and I'm playing one of his old live streams from a couple months ago. I think we said it was before May of 2025. This was an 8 p.m. live stream he did a couple months ago because I miss Bill. And then what I didn't realize was he was going to play Judge Fleischer. So now we're watching Bill and Judge Fleischer from a while ago. Adam, I don't know. I know it was before May, but I don't know when before May it was. And I keep talking to Bill, but he won't answer me. Hold on. Bill, blink if you're okay. Bill, if you are terrified of Emily, don't move. Oh, guys, he's scared of Emily, which he has every right to be. Did they say February? Did they? Gotcha, Adam. Gotcha, Adam. Nice shirt, Bill.
Someone bond in the first place is to.
That's an inside joke between me and Bill. Nice shirt, Bill. But I don't know if he's ever going to hear it and laugh. Ha ha ha. He will belly laugh if he hears me say that. You guys don't even know. Tears will run out of his eyes.
To establish that they come back to court. So are they a flight risk? And then also are they a dangerous community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I could call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here 2 prior settings before. I know you're concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, one of the 2 main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can. I mean, we can call that, Your Honor, but sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the Scram device.
We have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call.
All right, so I'm going to interrupt it. That dog hates me. My wife ended up with a new dog, a little 3.5-year-old Chihuahua, and that dog just pure hates me, and nothing brings me more joy in life than that.
Pretrial Services, Miss Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand?
Now I really miss Bill. Why did he have to talk about his dog? You know, now I really miss Bill. Bill, you're killing me. You're killing me.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked? These are,
Sorry, could you repeat what you just said?
sorry, I said, I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install condition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain. We do have a curfew of 9 p.m. to 6 a.m. and then a Scram device to be installed. And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the Scram device, can you tell us about that? Yes, so what exactly? What is that? What's the standard procedure someone's supposed to do? Yeah, so a Scram device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on Scram?
And I was not trying to establish her as an expert, just from her experience, what the Scram device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph. And I'm showing her now what's marked as states. For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
Why is Bill smiling right now? Why?
And I'm showing you what we want to see, Exhibit 6. Can you please tell us what this is? So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per. Okay, so this fairly accurately depicts an scram for embedded statistics. Yes. We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date? Yes.
Defense proceeded, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly? Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th. Say it again. 9:05 a.m. January 17th, 0% THC was reestablished for the dissipation of alcohol. Okay, and for those dates, the ones that match on what I'm showing you is THC Exhibit 2, the bond violation report. Can you please, do you recognize this? Yes. Can you please read the details of the violations here? It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has
Jude,
reported
I'm
one
so
consumption
sorry.
event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst. Thank you. We pass the witness.
Okay. All right. Good morning. I just want to, if you could turn to, I believe it was the States Exhibit 3, I think, for the scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So let me, sorry, that was a poorly phrased question.
I'm sorry,
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
No, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but
And
not
what,
expertise.
sure, and what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper,
Mhm.
environmental factors versus
Mhm.
consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No, okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so, one second. So is it fair to say that you've been thoroughly trained on the theory of SCRAM device and alcohol detection? Is that fair to say? That let me rephrase that. So, you don't have any actual technical experience with how the SCRAM device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. Is it yes or
I
no?
I still don't understand.
I'm trying to understand too.
Do I not understand how a SCRAM device works, or have I not for myself? And
Sure. So, this.
Hey, Bill. Bill, you have a microphone. You don't have to do all this work. You just don't have to. You could just pause the video and talk. People love that. People love it, Bill.
Pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I
We
partially
did
wrong
go
about?
over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as
I am actually paying him triple what I paid him last month. Easy. Triple the amount easy.
well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no like, withdraw that question. So I'm just saying there was no like actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined
Good.
the report for that.
Well,
And also reviewed some of the.
Is the prosecutor wearing my shirt? Hey, woman.
Peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't, they'll just kind of do their jobs, right? I'm glad that you want a further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation, how a SCRAM device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Question asked and answer.
We don't shut up, JK.
Okay, just let's go.
Wait. I got something for that.
I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that
It's
there was.
Sure. I'm just saying that this, I'll make my argument in closing. I don't have any further questions. Thank you.
Oh, it's been a while.
Or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if this scram device has been tampered with? Yes, we get notified of tampers and consumption events. And you get notifications if it's been cut off. Like, just what's been going on with the scram device, you get those notifications? Yes. Okay, thank you. No further questions.
Matt,
No further questions, Your Honor.
okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to
So
be prepared
freaking
by
cute.
someone else who is not
My
here to testify.
gosh.
There's no
Oh my
ability to
gosh.
cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol.
Yo,
And I would ask
speaking
that,
of
Your
adorable,
Honor, again, not revoke the bond, keep it as is.
later today we have a live stream, content provided by Josh from Utah. We're going to go back to the firing squad case. We're going to hear arguments and we're going to hear from the family, and it's awesome. It's so good. Starts at 1 o'clock, which is, I don't know what time. Just go to the link and it'll tell you when it starts. And then there's no stream tomorrow. All right, there's no stream tomorrow morning. It's my dad's birthday. I'm taking off. Yes. So anyway, we have a few more minutes to go. I just wanted to get y'all before you jetted.
My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive
He had a positive THC, right?
Yeah,
As
that
well?
we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta, whatever. Regardless, it's number 3, goes with you. All right, off the record.
All right.
Sorry.
Any
Thank
second
you,
now, Bill's
but I
going to
just
say
can't-
goodnight
with an
to
open
me.
dip behind
You
a
guys
third,
can listen
that's
in.
it.
It's
I
fine.
can't just keep doing it,
I
you know?
know.
At some point, I become an
I
enabler,
know.
and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am gonna raise it, right? I'm gonna raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not cheap, Your Honor. So if you could keep that.
I'm not cheap, Your Honor. I am, guys.
You know, and it's
very
I
cheap.
understand.
I
representing him in
promise you.
Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Hey,
Yeah.
but tell him this, that he's lucky that it didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503. Yeah.
Judge, quick on this one. I should have called her up. She was.
Look at what we're watching. Look at what we see. We see the judge. We see Bill. He's about to say goodbye to me. And we see Victoria running that courtroom like she owns it. Oh boy, oh boy, oh boy, oh boy, oh boy, oh boy, oh boy. The only thing that would have made this better is Pac-Man suit. It's the only thing that would have made this better. Okay. It's time to have Bill say goodbye to us. Here we go.
All right, everybody. Thank you so much for coming out. I think I'm going to be done for the night. I got to get ready for Kathy's live in the morning. So we'll see all you guys in the morning. You have a good night.
Whoops,
Good evening.
I restarted it.
I
didn't mean to restart it. Thank you, Bill. Love you, love you, love you, love you, love you, love you. Thank you, Judge Fleischer. Love you, love you, love you, love you. Victoria, thank you for that. Thank you for that happy ending, Victoria. No, he's not. He's not. I took this from back in 6 months ago. All right, guys, you'll be at the OJ stream in 2 minutes. Thanks for coming out. Please come out to my live later today. It'll be fun. It'll be when the freaking sun is out, which is just crazy. I'll see you later. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's love cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. a giggle, she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a wake there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray,